This is Shruti and this is my second video. So you have already guessed what is this video all about as you have seen in the thumbnail. So this is my second video and it is about the recent Supreme Court of the United States judgment and in short we call it SCOTUS judgment regarding the birthright citizenship. So in this judgment, on 30th June 2026, the Supreme Court of the United States, in short, SCOTUS, has upheld the 14th Amendment of the US Constitution. In this judgment, the SCOTUS has uh, struck down the executive order of the present President Donald Trump. In that executive order, it was provided to end the unconditional birthright citizenship that the US grants to any person who are just born on the US soil. In the 14th Amendment of the US Constitution, it has been provided that all persons born or naturalized in the US and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So, this 14th Amendment of the Constitution was was an issue for a long time, and even in the Trump's administration, a major concern or the central concern, that is uh, the anti-immigration politics of his main movement, that is Make American Great Again movement. So, firstly, just want to tell you the background or the history of the evolution of this 14th Amendment. I think the main reason for the evolution of the US citizenship and this 14th Amendment was closely linked to slavery and racism in the country. In the original constitution of the US, there was no such provision at all. Even there was no definition of the citizen. No word was there. Actually, it was guided by multiple factors. Like in the US, individual states have the right to make laws on their own. They can make laws on the civil and political rights, which includes voting and property ownership rights. And there was a law, the Federal Naturalization Act 1719, which which is very much clear that only free white persons can be eligible for being a citizenship of for having a citizenship of US. So there was a major concern and there was a varied practices across the US in different states. Like in the northern states, free black residents had some rights, but not all, like voting rights. But in southern states, they were denied to them. That is, citizenship was denied to them. So this situation was changed in 1857 when there was a Supreme Court judgment in 1857. Like it was very unwelcome judgment of the Supreme Court in which it was held that no black person can ever be a citizen of the US, and this has resulted into a this has resulted to a filing of a plea by a person named as was an enslaved black man named as Dred Scott, and he filed a plea for his freedom and for the freedom of the black men. Then in 1865 only, there was an amendment that is known to be the 13th Amendment, which ultimately abolished the slavery. But till now, there was a confusion regarding the freed slaves. In the previous judgment of 1857, like it was provided that no black person can ever be a citizen of US. So there is a kind of ambiguity in the system. Then only in 1866, finally, Civil Rights Act was passed by the Congress, in which it was provided that any person who born in the country is to be a citizen of US. And there also one problem is there. Like President Andrew Johnson vetoed against it. But then the Congress was against this veto and they supported this law, that is Civil Rights Act. Then for the future uncertainty, to avoid such uncertainty in the future Congress, it was decided to write this law into the Constitution. So, but finally, by 14th Amendment, it has been written in the Constitution that whoever born in the US to be automatic citizen of the US. Now the situation is like now the Trump administration, they have some arguments against this birthright citizenship, and they have argued like now this remedy is redundant and it is of no use. Like this was for the specific situation of the foreign slaves, and now the situation is no more existing. So that should be avoided, and that should be removed from the Constitution of the US. However, by this judgment of the SCOTUS, uh, now again 14th Amendment has been revived, and in this judgment, the majority of the judges have the view that the framers have some intent behind this legislation, and they have a view that they have the intent like they want some universal language so as this promise won't be limited to one group or vulnerable group or to one vulnerable group. So to just at the narrow judgment or the narrow legislation, 14th Amendment was included in the Constitution, and in this way, it was justified that 14th Amendment is a constitutional, and thereby, by this judgment, it has just end the executive order, and so that's the thing. So now, what I just want to know, what are your views? So let me know your comments or opinion down below the comment section. So thank you very much.